welcome everybody to this barrier crimes committee meeting, joint subcommittee. And I want to remind everybody naturally to mute your microphones unless you are speaking. And I'd like to ask the clerk, Mary Ann, to call the roll, see if we have a quorum.
All right. Senator Serval.
Here.
Delegate Bagby. Delegate Samira. Christy Kelly. Christy Kelly.
She's logged in.
Yeah, I saw her come in. All right. James Abrenio.
Here.
Commissioner Land.
Here.
Commissioner Storin.
Sean, this is Gina. I'm here on behalf of the commissioner today.
Thank you very much. Vice Chair Price.
Here.
Chairman Edwards.
Here.
Christy Kelly, are you on?
I just texted her.
Okay. Let's give her just a moment to respond.
Hi, this is Christy. I'm sorry.
Hey, thank you very much. Mr. Chair, you have a quorum.
Hey, thank you. I see we have the clerk, Sean. Thank you for good work. First of all, I want to welcome everybody to this, I think, very important joint subcommittee or joint study. What we're looking at is barrier crimes more broadly. We've had barrier crimes going back to probably 20 years. And they've grown and grown and grown, and sometimes they become unwieldy. So we want to look at whether or not we can organize it better. And Sarah Stanton did a heck of a job several years ago in the General Assembly organizing the barrier crimes according to different categories: child care centers, adult care centers, and so forth. And I think that we can start with that. She did a terrific job a number of years ago. Secondly, question is, do we have too many crimes? Are some of the crimes applicable? Are there some of the crimes, can we remove them? It's a long laundry list that goes on and on and on. And then the third category is, should there be exceptions and waivers? And should we broaden the exceptions and waivers? And thirdly, is there like a statute of limitations, a time limit, 5 years for assault and battery? I had a case years ago in Roanoke where a guy was 53, I think, years old. And when he was 23, he and his brother got in a fight. And so he could not be the chairman of a daycare center, even though everybody wanted him to be, because 30 years before his brother got in a fight. And so should there be some kind of a exception there, or should there be a waiver, or should there be a statute of limitations? And then what changes should be made in the criminal history records check? How can we improve it to make it more efficient for everybody? So these are some of the things we need to talk about. And at first, I'd like to call on various agencies who've agreed to come: the Department of Social Services, the Department of Behavioral Health and Developmental Services, and the Department of Health. And so with that overview, I'd like to ask if Gina Berger, I believe the Chief Deputy Commissioner, are you here?
I am.
Good. Thank you very much for your presentation, and I look forward to hearing from you. So thank you very much.
Great. Good morning, Mr. Chairman, members of the Joint Subcommittee. Gina Boyle Berger, Chief Deputy Commissioner at the Virginia Department of Social Services. We have a presentation for you today on the various areas of our work that are impacted by barrier crimes. There's a whole host of things, so including our licensing division, both our child and adult programs, child welfare and family services, even some considerations for child support and benefits. And I want to acknowledge my team members that helped put this presentation together and who are also on the line with me today. So M. Parente and Nikki Clark from our Division of Family Services, and Sharon Lindsay from our Division of Licensing. Let me see. Okay, so just starting off, generally, what are barrier crimes? So they are convictions of any crime as defined in Virginia Code 19.2-392.02 that disqualifies an individual from certain types of employment, volunteering services, or to operate certain regulated businesses. In terms of where you see volunteering services, as we get into this, you will see that for us, this also means individuals who would like to become foster and adoptive parents. There are also barrier crimes that prevent them from doing so. The barrier crimes include prior adult and juvenile convictions or adjudications based on a crime that would be a felony if committed by an adult within or outside of Virginia. Barrier crime statutes were originally designed to protect vulnerable adults and children, but as you said, Mr. Chairman, over the years, they have definitely grown in terms of the number of crimes. And as we have, evolved in our care models and service models, the development of peer support services has really been shown to be an effective tool in improving outcomes in serving children and families and individuals. And there is greater recognition that because of the historical racial inequities and some of the barriers to employment that the statute has created, it's made it harder for us to provide this sort of new model of care of peer support services. And so you probably have heard about that before in terms of behavioral health, and I'm sure that DBHDS will outline that, but we've also seen that as a barrier for child welfare services and family services too. So the types of barrier crimes in 19.2-39202, there are 6 clauses that outline barrier crimes. So the first 2 clauses are various types of harmful or violent crimes. The 3rd and 4th are drug-related crimes. Clause 5 includes any offense for which registration in a sex offender and crimes against minors registry is required. And then clause 6 includes any other felony not included in those other clauses unless 5 years have elapsed from the date of conviction. So in terms of the Virginia Department of Social Services, this statute applies and impacts various components in our oversight of child and adult programs, including child care programs, licensed child placing agencies, foster and adoptive parents approved by a local Department of Social Services or a child placing agency, impacts children's residential facilities, assisted living facilities, and adult day care centers. So getting into sort of the specifics of the crimes that apply in these various areas, for child day programs and licensed child placing agencies, the statute prohibits hiring anyone or approving a foster or adoptive parent who has a conviction of any barrier crime. There are certain exceptions that apply to this. At the end of the presentation, I have the more detailed exceptions as backup slides, but I will say that there are generally some criteria that get applied for exceptions. In terms of children's residential facilities, the statute prohibits hiring anyone with a conviction or pending charges for those harmful or violent crimes outlined in the first and second clauses of the statute, and then certain drug-related crimes in clause 3. Sex offenses and crimes against minors in clause 5, and a conviction or pending charges for possession or distribution of drug-controlled substance within 5 years prior to application, or if someone has failed to pay court fees for that crime. For our assisted living facilities, the statute prohibits hiring anyone with a conviction of the Clause 1 harmful or violent crimes. A program may, the statute does say that a program may hire an applicant that's convicted of a misdemeanor barrier crime, as long as it does not involve abuse or neglect or any substantially similar offense if 5 years have elapsed since the conviction. So in terms of how this gets implemented, our Office of Background Investigations works with a vendor field print to take fingerprints and submit them electronically to the Virginia State Police and the FBI. And then the Office of Background Investigation screens the National Registry to determine whether a barrier crime conviction exists. And then our office provides that notification to our regulated and licensed providers, and also performs this for the Department of Behavioral Health and Developmental Services, children's residential facilities that are licensed, and that notification comes via letter regarding the individual's eligibility to provide services or care based on that background check. The office does attempt to respond to qualified inquiries within 15 business days. So we pulled some data that we thought would be helpful to you all in looking at the most common crimes that result in an individual being determined to be ineligible for employment at our certain licensed programs. So the most common crimes resulting in an ineligible finding for child day programs are assault and battery against a family or household member, and then a felony within the last 5 years. In terms of the child placing agencies, so this is both employment for and in looking at placement for foster and adoptive parents. The most common crimes resulting in that ineligibility is assault and battery against a family or household member, and then the drug-related crimes of distribution, manufacturing, selling, and intent of a controlled substance. In terms of our children's residential facilities, the most common crimes that result in ineligibility, again, assault and battery against a family or household member. Mr. Chairman, I think you brought that up in your example. We do, as I said before, have some exceptions in the statute and some waivers that the commissioner can grant. And those are pretty complex, and I'll show you a couple of the specifics of those, but most of them require multiple criteria to be met. So that's sometimes a time lapse since the conviction, to a requirement that the crime not involve certain acts. So obviously crimes against minors often are in our children's program statute. Having some of them require the governor to restore an individual's civil rights in order to be eligible for the exception or the waiver. And then there's also some requirements for participation in certain treatment and rehabilitation programs. So just in conclusion here, the Virginia statute includes a lifetime prohibition for most barrier crimes. We do know that barrier crimes have become problematic for service providers to find qualifying employees, and there are critical shortages in the social services workforce, in the child and adult facilities and programs that are licensed by social services. We also see that barrier crimes prevent employment in other job sectors, and this really impacts our non-custodial parents who are paying child support. And we see that, this results in accumulation of debt and increased likelihood that our that the custodial parent will need other benefits like TANF or SNAP or Medicaid. As I mentioned before, new models of peer support care suggest that there are improved outcomes for clients and patients, but barrier crimes are a challenge to hiring those with lived experience to help be those service providers. And what we see also is that barrier crimes are contributing to a shortage in foster parents, particularly individuals who wish to foster or adopt a family member. So the barrier crime statute does apply to kinship caregivers as well. And just on the next couple of slides, I'll just say that, and this is in your materials, there are quite a few exceptions in the statute, again, that deal with like a lapse in a time period since the conviction, or required to meet certain criteria. And you can see that in your materials. And with that, I will go back and just pause to see if there are any questions.
Any questions? Don't be shy. Okay.
Chairman.
Gina, that was very helpful.
Mr. Chairman,
Yeah,
Mr. Rebel.
Senator Searle.
Thank you, Mr. Chairman. And I don't know if this is a question from Ms. Berger or a question for you, but I believe, at least in the DSS world, there's also some statutory prohibitions on receiving certain benefits based on certain convictions. And are there any restrictions besides TANF? I know there's prohibition for what, felony drug convictions or something like that.
Yes,
are there any others?
That was previous. So this past session in the 2020 regular session, you all passed legislation to remove that prohibition based on, and it was specific to drug-related felonies. So both for TANF and SNAP, that prohibition has been removed.
Right, Mr. Chairman, additional question.
Senator Searle.
Thank you. Ms. Berger, are there any others like that? I mean, I understand this presentation was focused on employment, but are there any other statutory restrictions on the receipt of benefits, any other kinds of benefits that have to do with a criminal conviction?
I don't believe so. I believe we looked at that last year in the last session, but I can confirm that with our benefit programs folks and get back to you.
Thanks.
Okay. Any other questions? Yeah, these are good questions. Thank you. Okay, we'll move on then to the Department of Behavioral Health and Developmental Services. Stacy Pendleton. Stacy Pendleton.
Yep. Good morning, Chairman Edwards and committee members. Get my screen up here. One moment. All right. Thank you for allowing us to present from the Department of Behavioral Health and Developmental Services. I am Stacy Pendleton, the Chief Human Resources Officer, and we're going to go through some of the information. You will see some information that's similar to social services, and then kind of how we're slightly different and the barrier crimes. So the first slide here talks about our code sections. Our barrier crimes are under 37.2-314, 408, 416, and 506. This is the code section that determines how we apply the barrier crimes. So 314 is for our facilities that we run. 408 is children's residential, so that would be the Commonwealth Center for Children and Adolescents up in Stanton. 416 is our private providers that we license, and 506 would be CSBs and behavioral health authorities. So for the first bullet here is a condition of employment. The department facilities require a background check for those positions of employment that were not hired before July 1 of 96. And then anyone who receives, monitors, or disperses funds for our agency if they were not employed prior to July 1st. And then the second is for licensed providers and CSBs. They run the background checks against that barrier crimes for anyone who accepts employment in a direct care position or supervising any direct care, an applicant for a sponsored residential service provider, any adult living in the home of an applicant for a sponsored residential provider, or a person employed by the sponsored residential service provider to go and provide services in the home. So we have 176 barrier crimes that would disqualify individuals from employment in licensed adult and child behavioral health and developmental services programs. All four of our codes reference 19.2-392.02. We do have one barrier crime, the felony possession of a controlled substance, that has a 5-year time frame, so you need to be past that. And then our licensed providers, which include the CSBs as well, they can hire an individual if they were convicted of a misdemeanor assault and battery or misdemeanor assault and battery of family member if 10 years has passed, but there can only be one conviction. So this does come in play later on. We do have one area that would kind of be an exception to the barrier crime listing, and that is a screening process that we have in code that involves mental health, illness, and substance abuse. So there's 26 crimes that have been deemed screenable. And so if you have been convicted of one of those crimes, the employer can decide that they want to go through the screening process if these things have been met. So it's been 5 or more years since the conviction. The charge must be related to their substance use or mental illness situation, completion of all prison and jail terms. They cannot be under probation and parole, have no pending charges in any locality, and have paid all of their fines, restitution, and court costs for any prior convictions, and have been free of parole or probation for those at least 5 years for all convictions. And so employers really have the ability, when they see one of these barrier crimes come back, to decide to start that screening process. There are licensed behavioral health providers who are set up as screeners, and they go through that assessment that we have to determine if the offense was related to their mental health or substance use disorder, and if they're likely to reoffend. The employer would get those results back, and then they have the ability to decide to move forward with that employment offer. There are a couple of differences when it comes to the licensed providers, CSBs, and the facilities. So the screening until this past General Assembly was only for our licensed private providers and the CSBs. This past General Assembly passed a law that allowed now facilities to do that screening, which has opened up potentially the applicant pool for our facilities. However, it is really only for adult mental health or substance use disorder programs, so it would not apply at our facilities, CCCA, which is Children's Residential, VCBR, which is our violent sexual predator facility in Burkeville, or at Southeastern Virginia Training Center, which is a facility for our individuals with developmental disabilities. So it only is applicable for substance abuse and mental health programs. And then another difference for the screenables is the felony assault and battery of a law enforcement officer. So this only applies for licensed providers and CSBs. So that one screening would not be applicable to our facilities. So here in central office at DVHDS, we have a background investigation unit which conducts all of the background checks for our licensed private providers. We do use field print for that, just like social services. And we do provide the eligibility letters or ineligible letters out to our private providers. the CSBs and our facilities actually have the ability to run their own background checks. And so they do the same process as we do, but we just provide consultation, technical advice, policy guidance for the CSBs and the facilities. We do, however, oversee the screening process for those screenable crimes. For no matter who that is, we provide that service here within central office. We also are working on always internally looking at things that we can do to enhance our workforce, to look at the process, what crimes, is there a legislative option? So in 2019, we did start 2 work groups internally here that are looking at the screening process and putting more standardized process and tool out there to enhance the number of screeners we have and consistency, and then working with other stakeholders with any legislative options that we can do. So this is a welcomed subcommittee here. Certainly we have a challenge and that we are the public safety net, and we are always having issues with recruitment of qualified applicants as we try to meet the growing needs of the behavioral health and developmental services workforce. For many individuals seeking employment, their barriers are decades old, 20, 30 years, and that continues to follow them. And we have certainly many qualified applicants who have valuable services and lived experience. We know of many cases where folks have gone back and received their degrees, they're licensed, they have certifications, and the barrier employment is not available to them because of these barrier crimes. This is some data that we had pulled. It is from July of 2017 to June through 2019, and this has to do with assault and battery. These are 2 of the crimes that we see most often, and you can see that the timeframes, anything that was further back than 10 years or that they've got more than one conviction, impacts folks. So we have 220, 168, 100 individuals, and 50 individuals. So this just demonstrates that there are folks out there looking for employment, and this is keeping them from doing that. I do have a couple of examples that I wanted to show you. We've had individuals apply to be a sponsor for their daughter who had several disabilities. And per law, the mother and her husband are required to complete a background check. The husband was convicted of a barrier crime in 1983, has had no other convictions on his record. And in order for the mother to be the sponsor, he would have to actually move out of the home. He would not allow to be there in order for her to do that. And then we have had cases, an individual had been in recovery for over 18 years, became a licensed clinical social worker and applied at one of our licensed providers. And they happened to have 2 convictions of misdemeanor assault back in 1992 while they were in active addiction, and they were found ineligible because the screening only applies to that one assault. So these are just some of the areas that, examples. So I will open it up for questions at this point.
Okay. Any
Mr.
questions? Senator Searle.
Thank you. I have a bunch of questions. Can I ask?
Okay.
Mr. Chairman, can I ask for just permission to ask a series of questions without going through you?
Go ahead.
Thank you. Thank you. Appreciate that presentation. My first question is on the domestic assault. Do convictions count, or does it? I understand convictions count, but does it count if you get a charge that's continued for dismissal and you stipulate you're guilty and then it's dismissed after a period of time? Do you all treat those as convictions, or do you only treat convictions as convictions? Because the vast majority of domestic assaults I see are charges that are continued where people stipulate they're guilty and they're dismissed. And under an expungement statute, you can't get that expunged because you stipulate you're guilty. And
But it's, yeah, if you go through, say, the different programs that are offered in those situations, it's not a conviction. It would be a deferred finding.
Okay, those don't count.
As long as, yeah, it's dismissed.
Okay, second question. I'm curious about the specific logistics of what you described. When you're talking about the background checking that's occurring by you
Okay.
all and by the employer, physically, how is that done? Are we talking about VSIN or NCIC checks? Are we talking about you all go out to a private provider and you procure it through a third party source like a Hire Right or Experian or TransUnion or Lexus?
No. So we actually work directly with our licensed providers. And those, there's a process where they go and log into FieldPrint. That's the third party vendor who you actually go and have them fingerprint you. Then that's run through the state police and the FBI, and those results come back here to us electronically.
Okay. So
is that answering your question?
No. So is that I understand it's a third party that does the prints, but is the background check done through VSIN and NCIC, that is the National Criminal Information Center and the Virginia Criminal Information
Yes,
Center?
I'm sorry. Yes.
Okay, so you're not using a private database to do the background check.
Correct. And I apologize, didn't understand your question. Yes.
Okay.
We're not using.
Okay. Are you familiar with how the private employers who you deal with, how they do their background checks? Are they doing it using a private third-party service that accesses a database, or are they, from your perspective, only using VSIN or NCIC?
All three entities, so private providers, our facilities, and CSBs are going the same process. They are not using a third-party vendor.
Okay. Next question is, do you know of any language in is there any language in the code that talks about how you treat an out-of-state offense? Because there's some offenses that out-of-state might qualify as a misdemeanor, but in Virginia might be a felony, or vice versa. How do you all treat those situations when you're talking about out-of-state charges?
The code does speak to that. I have my colleague here in the office who actually handles it on a day-to-day basis, so she's getting me that information.
Okay. Mr. Chairman, I think that's all. I'm sorry. Last question. Well, I understand that you all can screen somebody, and as part of maybe somebody has a certain kind of misdemeanor conviction, or I guess a lesser felony, and you all could screen them and say, well, notwithstanding the fact they have this conviction, we're going to go ahead and green light them for this benefit. However, an employer doesn't necessarily have to honor that, right? So I guess my question is, are you aware of whether any insurance companies either prohibit the people who you regulate from hiring people with criminal histories, or sort of give them, hit them with increased insurance premiums because of the risk associated with hiring somebody who has a criminal history?
That I cannot answer, Senator, so we'll get you that information.
Okay, and last thing, I guess.
So I'll get you that information on both questions.
I guess my last question is, I've been talking to some of my colleagues about a system they have in North Carolina where you can go and get judicial blessing to do certain types of jobs. And one of the advantages of in North Carolina of getting that judicial approval is that the permission of the court and the court order provides the employer with immunity from any type of negligent hiring claim relating to hiring a person with that criminal history. Are you aware of any other states that provide any type of immunity to employers who put somebody through a screening process like yours, and the person is approved for employment? Because I could see a situation where you guys might say that it's been 7 or 8 years, but somebody still looks at the person's criminal history and says, I don't know, it's going to increase my insurance rates, or I might get sued, or if somebody finds out it's a problem or whatever. Whereas, the provision of immunity might provide them with some sense of comfort about having to worry about those things. I mean, are you familiar with any systems in any other states that provide that type of immunity for people once they've been screened?
I am not aware
Okay,
of that.
thanks. Those are my questions, Mr. Chairman.
Okay, anybody else have any questions?
Mr. Chairman, I do.
Chrissy.
Yes, my question was just, I noticed that there was a 5-year time frame for individuals who had substance abuse convictions, and also in order to get this special screening, it was also 5 years for substance abuse issues. And so I was just wondering why the 5 years? Is there some sort of reason that an individual who had a substance abuse issue in the past has to wait 5 years versus 1 year? Is there like any data or anything that was based on that you could talk about, or is that just
Stacy?
Senator Edwards? Yes, sir.
Yeah, did you
Yeah,
want to
I can.
Yeah.
I sure can. This has been in code for some time. I would have to go back and look at what precipitated them putting the 5 years in. The 5 years has to do with the conviction of any crime. So it's not just substance abuse. It's when you're looking at those screenables, any conviction that you had. So it's not just for that. And then the one was the felony possession. It has to be past 5 years. We'll look at that. We can get that information about back when they put this in code, if that was best practice at the time, based on the research. I don't have that history.
Okay. Any other questions? I thought, Stacy, your last two examples were really good examples of why we need to do something to improve the system. There are a lot of egregious situations like this. Yeah. And a lot of shortages
Thank you.
for people wanting to be foster parents and whatever. Okay. All right. Thank you. Any more questions of Stacy? Okay. We'll move on then to the Department of Health. Rebecca Allen, a Senior Policy Analyst for the Department of Health.
Yes, thank you, Chairman Edwards. If you'll give me one moment, I will get this presentation shared.
Okay.
All right, thank you, everyone. My name is Rebecca Allen. I am the Senior Policy Analyst at the Office of Licensure and Certification at the Virginia Department of Health, and I'll be speaking today about the impact of barrier crimes in our licensed medical care facilities and other licensed entities. And before we get started, I just wanted to point out the licensure and certification part, because it does have bearing on how barrier crimes impact the facilities here in Virginia. So if a facility is licensed, it merely means that they've been given a license by the State Health Commissioner to operate as that specific facility type. Certified means that they have met the conditions of participation to participate in the Medicare and or Medicaid programs. Certification is a voluntary process. Facilities do not have to be certified if they do not want to receive Medicare or Medicaid dollars. And a facility that is exempt from licensure may still be certified. Federal regulations, which would be part of those conditions of participation, do not require background checks for employees of certified facilities, but they do require that facilities comply with state law. So if state law requires that that specific facility have background checks, perform background checks, they will have to comply with state law in order to meet the federal conditions of participation and to continue to receive Medicare and Medicaid dollars. So I just wanted to make sure that these two terms are laid out for you at the beginning, because it will have impact on what we're getting ready to talk about. So for barrier crimes for the facilities that VDH OLC licenses, that is going to be any offense that's listed in Clause I of Virginia Code Section 19.2-392.02. And that one clause has, I believe, 138 offenses listed in it, as well as a catch-all provision of if they've got convictions for any of those 138 or any substantially similar crime in another jurisdiction. And of the nearly 140 offenses that are listed, they are split into any conviction or any felony conviction. So for the ones for any felony conviction, that's going to be your violation of protective orders, stalking, criminal street gang activity, dangerous use of firearms, commercial sex trafficking and prostitution, a riot, and unlawful assembly. So felony convictions for those types of crimes would be a barrier for our licensed facilities. Now there is a more extensive list of any conviction. So it does not matter if it is a misdemeanor or if it is a felony. If you have a conviction for anything in these sorts of categories, it would be a prohibition for employment. So that's going to range from anything from homicide, which includes murder, manslaughter, to conspiracy or incitement to riot. Your family offenses and crimes against children would be something like abuse and neglect of incapacitated adults, indecent liberties with children. There's quite the wide range of things here that can be a barrier for folks wanting to be employed by licensed facilities.
Mr. Chairman.
Mr. Chairman.
Yeah, Senator Sherrill.
Thanks. I think Delegate Price probably has the same question I do. If there's a presentation going with this, we can't see it.
Oh, I do apologize. It says that it's sharing.
Yeah, it says you're starting sharing, but
Try
we got a black screen. I think you might be sharing the wrong screen or something, or maybe.
All right, one moment. Let me see if I can.
Yeah. I was going to say, just try to unshare, and then share again and see if that helps.
Yep, let me try that again.
There you go.
There
Okay.
you go.
Okay. So the important terms and concepts, the barrier crimes piece that I had listed. So the any felony conviction, and this was the slide that I was on, and I do apologize. This is the any conviction for set. So it's quite extensive. As you can see here, anything from homicide to incitement or conspiracy to riot, paramilitary activity, arson, and other related crimes, carjacking. It's quite the list. Violation of the Uniform Machine Gun Act, for example. So any violation, misdemeanor or felony for these sets of crimes would be a barrier here in Virginia. So for the impacted licensees, there is a prohibition from hiring for compensated employment, so this doesn't touch volunteers, anyone convicted of a barrier crime, and the licensees that impacts is our licensed nursing homes, our licensed home care organizations, our licensed hospices, and any HCOs that have subsequently been certified as home health agencies. Because, just so you all are aware, once an HCO, they have to get the license first, and once they're licensed, they can seek certification so they can participate in those federal programs I had identified earlier. Once they are certified, HCOs no longer have to be licensed. They're exempt from licensure at that point. So because of that, the way the exemption works, HCOs that have been subsequently certified are separately listed. There is an exception, similar to the one that I believe DSS had touched upon, that they may still hire someone who has been convicted of a single barrier crime if that crime was punishable as a misdemeanor, does not involve abuse or neglect, and 5 years have elapsed following that conviction. Right now, there is no statutory mechanism to set aside the requirement to do the criminal records check or to set aside the barrier crime bar. While the state health commissioner does have the ability to grant variances to regulations, this is not regulatory, it is statutory. So right now, there's no way for us to waive any of these requirements. The only exception that we have is the one that you see here on the screen, the one for the misdemeanor 5 years ago that doesn't involve abuse or neglect. And you may notice looking at the list of facilities that I have here that hospitals are not included. So there's a separate statute for hospitals, which you see here on the screen, 32.1, 126.02. Licensed hospitals must obtain that criminal records check within 60 days of the start of compensated employment for any person who's not licensed by the Board of Pharmacy and whose job duties provides access to controlled substances within the hospital pharmacy. It only requires that they get the background checked. It doesn't prohibit them from employing them, regardless of what that CRC shows. And not every hospital in the Commonwealth is licensed. So the big one that is a great example is UVA. They are not licensed. By us, they are certified to receive Medicare and Medicaid dollars, but they do not have a license. So that because of that, they're not subject to the requirements of 32.1-126.02. There are other hospitals in Virginia that aren't licensed by VDH as well. Psychiatric hospitals, for example, are not licensed by VDH, so this provision of code would not apply to them. Though again, they may be certified. So the criminal record check process for our licensees, both new and ones that have been in existence for a while, is different from what our sister agencies have touched upon. VDH does not have a role in facilitating that background check process. We do not have a or division within VDH that handles that for our licensees. Instead, the licensees interface directly with the Virginia State Police to get that criminal background check done for their employees. And that's because of the way the law is worded. The burden is placed on the licensee to do those checks and specifically have to get that information from the Virginia State Police. So when you have a new entity that has not yet acquired a license from the State Health Commissioner, they have to utilize paper forms to submit that information to the Virginia State Police to get those background checks. Once they have a license from us, they have the option, they're not required to set up an online account with the Virginia State Police so they can request those CRCs electronically. As you can probably imagine, submitting them electronically does expedite the process of obtaining them. And when they have that online account, they can also receive the CRCs through an online portal, provided that the CRC comes back clear. So for the general records check process, once they've already, they're licensed, they are interfacing with VSP, they submit the paperwork and fee to the Virginia State Police. One of the requirements that's placed on the new employee is that they have to sign a sworn disclosure statement attesting to not being convicted of or having charges pending of a barrier crime before that CRC is requested. While the statute says that they cannot hire someone who has a conviction, the sworn disclosure statement has to cover both convictions and charges pending. Assuming that the form is submitted electronically and there are no barrier crimes, that CRC is going to be sent to them via email, usually within 24 hours. If there is something on that CRC, it's going to be mailed to them by postal mail, regardless of how it was submitted, electronic or by paper mail. We're looking at response times of 2 to 4 weeks typically. The CRC results have to be part of the employee's personnel file, and the employers have to have that CRC within 30 days of the start of employment. Has to be original. It's not dated more than 90 days prior to the start of employment. So you've really got a 120-day window to work with. You can start 90 days out from when you want to get them employed if you would like. So there's a 120-day window for them to get that CRC in. And it remains valid as long as that employee remains in continuous service. And our field staff have observed that there's a 50-50 split between paper versus electronic requests for CRCs. Excuse me. When it comes to the enforcement of the barrier crimes requirement, we conduct licensure inspections to make sure that facilities are in compliance with state statutes and regulations. If a licensee is also certified, either VDH OLC or an accrediting organization will conduct a federal survey on behalf of the U.S. Centers for Medicare or Medicaid Services to make sure that they are also in compliance with the conditions of participation. And if we are conducting the federal survey, we do our best to combine those so that we're only having to go in once, and it's to be more efficient both for our time and resources and the time and resources of the facilities. When it comes to specific barrier crimes, deficient practices, and issues that we have observed that they do have a barrier crime on their CRC, but the person is still employed, that they are not meeting the time window of getting that CCRC completed. Use of a third-party vendor for background checks rather than the Virginia State Police, because it is required that they have to go to the Virginia State Police. That's what the statute directs. They don't have the sworn statements in the personnel files, or they are missing entirely. Administrators believing that the CRC requirement doesn't apply to them. Failing to include the CRC process in their policies and procedures. And then, of course, allowing an employee to work independently prior to obtaining a CRC. And that last bullet point, the law does allow during that 30-day window between start of employment and the deadline to get that CRC received. The employee can begin to work, but they have to be supervised by another employee who already has a clear CRC and is with them when they are performing work. So the working independently is essentially they weren't being supervised. We do receive a slew of questions from our licensees about the barrier crimes process. They frequently ask how they go about requesting electronically the CRC, particularly if they have not yet received a license. They also want to know if a person's been convicted of an offense that's not listed as a barrier crime, but is related to abuse and neglect. Is it a bar to employment? Of course, as I touched upon, they can't use third-party vendors, but they do ask that if the vendor has a national search and it clearly states that VSP records were searched in conjunction with it, is that acceptable? Can they use the FBI rather than VSP reports? We get that one much more commonly from licensees who are up in the Northern Virginia area. Why doesn't VSP include information from other states? Why do all compensated employees, even part-time and administrative staff who may not have direct patient or client interaction, have to have a CRC? And what exceptions, waivers, or appeals are available to hire someone who doesn't have a clear CRC, which, as I pointed out earlier, right now there's not a mechanism for us to have exceptions, waivers, or appeals, except for the one that is already built into the statute. So the issues both that we've seen with our licensees and that our subject matter experts have discussed is all of our facilities, licensed facilities, have a barrier crimes requirement, except for the hospitals. And as I touched upon, it's just to get the background checked. It's not to actually be a bar to employment. And there is a loophole for hospitals that are exempt from licensure. There is a lack of an online CRC process at VSP for entities prior to being licensed. Lack of a clear barrier for persons who have abused, neglected, or exploited adults or children in electronic forms. Our field staff, we have cited licensees in rural areas for knowingly hiring a person with a known prior criminal history, but that is largely because the caregiver pool is limited in these areas and client and patient demand is high. So one of the things that our subject matter experts have discussed, the value of having a waiver or some other similar process for hiring specific persons who may have that criminal history that is, we say 10 here, but whatever metric of time you would like to look at, that they have an old criminal history, they haven't had any other issue, they meet the job qualifications, and there isn't any other qualified candidate with a clean CRC available. We don't have a way of allowing them to take that position. So that's something we think would be worth examining. And then the need for plain statutory language about the exceptions to barrier crimes, perhaps to reconsider the time frame between a single non-abuse, neglect, misdemeanor and hiring, which is 5 years presently, and reconsider how to handle persons with felonies or multiple non-abuse, neglect, misdemeanors on their records. Because right now, if you have a felony, it's a complete bar. It's one of the listed felonies. And if you have multiple non-abuse, neglect, misdemeanors, that is also a bar, because the exception that we have is for a single misdemeanor that is not involving abuse and neglect that is over 5 years old. So with that being said, are there any questions that I could answer for this joint subcommittee?
Okay, any questions for Rebecca Allen?
Mr. Chairman, I have questions.
Yeah, Senator Zerbel.
Thanks. Starting backwards, Mr. Chairman, could I also ask for permission to ask a series? Don't have to keep going through
as you like.
Thank you. I'm just trying to move this along. Thanks for the presentation. I'm going to go backwards, I guess, from where you ended. It looks to me like you're suggesting there ought to be some sort of an administrative process. Were we to consider some sort of administrative process to get approved? Most of the time when you have some kind of a process where decisions made after a contested hearing, there's an allowance for an appeal. Who would you imagine an appeal going to if, for example, somebody got denied in this process? Who do you think that appeal ought to go to, or do you aware of any other states where the appeal goes somewhere?
So within the bounds of, excuse me, Mr. Chairman, in answering the question, within the bounds of the Virginia Administrative Process Act, what I have observed both at this agency and other agencies that I've worked at here in Virginia is there's a preliminary decision based on essentially a paper filing. And then if that preliminary decision is an adverse one, the person is then able to ask for an informal fact-finding conference. And within VDH, those are adjudicated by our adjudication officers. So it's in person, or in this time of the COVID-19 pandemic, virtual in person, informal hearing setting. And the adjudication officer comes up with a recommendation that is then provided to the commissioner, and the commissioner makes what is considered a final decision or agency decision on the matter. And if that agency decision on the matter is still adverse to whomever the person is, at that point, the Administrative Process Act does afford them the opportunity to appeal that through the court system.
Thank you, Mr. Chairman. So I guess you're saying that you would see that this would be governed by the Administrative Process Act, like other administrative decisions, is the way you would envision it working if we were to have something like that.
Mr. Chairman, yes, that is correct. In the absence of any other specific instruction within the statutes to not use the Administrative Process Act or to use a special process that's not otherwise identified in the APA, that is what we would use, is the Administrative Process Act.
Okay.
So the General Assembly, of course, can come up with any sort of particular provisions that they would want us to abide by that's outside or beyond what the APA provides for. And if they did, that's what we would follow.
Okay. So you also talked about how some of your entities are licensed, some are certified, and I guess some aren't regulated at all. I'm not quite as familiar with the whole hospital regulation process, but are there any other third-party sources that regulate? Similar to my question before to the prior presenter, are there any other sort of third-party sources that provide restrictions on hiring people with criminal histories? For example, people's insurance policies or accreditation policies, or other sort of standards from third-party organizations which might disincentive somebody, an employer, from hiring somebody with a criminal history, even if you guys did greenlight it?
There may be. I do not have enough information to be able to answer that question for you definitively. So in the case of, for example, of hospitals, while they are not statutorily required to have these bars to employment, there's nothing to say that they can't, as an organization, introduce them themselves. It's just that there's not a statutory mandate for those to exist, like there are for our licensed nursing homes, hospice, HCS.
Okay. You also mentioned that one of the common problems that you see, or deficiencies you see when you all do your audits, is that sometimes you find employers using private background check services to do criminal history checks instead of using the Virginia State Police, which I assume is an NCIC and a VSIN check, both the national and the state check through the state police. But are you aware of whether or not your regulated licensees, or the people you all oversee, typically will use a private background check service to pre-screen people they will consider hiring before they take the step of hiring them and then putting them through your process? In other words, if I were trying to hire somebody to be a phlebotomist or a nurse or some kind of technician in a hospital, and I would want to have to go through all this process with you all, I would probably want to pre-screen them during the hiring process so that if I know if they have a crime already, I'm not going to waste my time putting them through the official state process. So are you aware of, is that a common practice? Do the employers during the hiring process pre-screen people using these private background service companies? And then when they get them to you all, they put them through the official process? Would you say that's common?
I unfortunately do not have any information on hand to be able to answer that question, but I would be happy to circle back with our field staff and their supervisors to see what their field observations have revealed on that point.
Okay. And I guess last thing is, are you aware of how this works in other states? Are we out of step with the rest of the country on this stuff?
Having not conducted a full 50-state survey of how criminal records checks are done in other states, I believe that other states may be a little bit more permissive in terms of where they can get the background checks from. as I said, the statute puts the burden on the licensee to go and get that record check from the Virginia State Police directly. And because it's built in that way, there's not really a ton of flexibility. I believe other states do have a little bit more flexibility in being able to work with third-party vendors. I do not know, and would be, of course, happy to go and get this information for you about whether our list of barrier crimes is in step with other states, if it's more restrictive, less restrictive, and the extent to which licensees are covered by the barrier crimes, if it's all licensed facilities, which would include hospitals, or if it's the more abbreviated list like what we have here in Virginia. I'd be more than happy to go and get that information for you in the joint subcommittee.
Thank you.
Any other questions? Okay, thank you. It's been very helpful. We're a little behind now, but now we're ready to go on to the stakeholder presentations. The Aging Services and Home Health Care and Hospice agencies. Dana Parsons with Leading Age Virginia. I've known Dana for many years. Dana, step right up.
Good morning, Mr. Chairman and members of the Joint Subcommittee. As Senator Edwards said, I'm Dana Parsons, Vice President and Legislative Counsel with Leading Age Virginia. Leading Age Virginia is an association that represents the not-for-profit continuum of aging services throughout the Commonwealth, including nursing homes, assisted living, senior affordable housing, continuing care retirement communities, life plan communities, adult day, home care, and hospice. I know we've had many presentations and many to go through, so I won't take up too much of the subcommittee's time, and just let you know that the major issue that we have heard from our membership is the process that it takes to conduct a background check. It can be very time consuming, resulting in lengthy time delays in receiving the results, and also the inability to choose a service provider to conduct the background checks because an employer is required to conduct the checks through the Virginia State Police. Therefore, if an employer wants to go over and above the current requirements and conduct a federal check, this process requires obtaining and paying additional service provider to conduct the federal check. So within our membership, that really seems to be the major problem regarding the process for conducting the background check. I'd like to read to you just a quick example from a continuing care retirement community that I heard from this morning. They indicated that when they have the person complete the sworn disclosure form and the background release form after they've accepted a job offer, they enter that information on the state website. If it comes back clear, then they get all the information they need right away. If there's something on the report, such as a speeding check, a speeding conviction, a bad check, the message says processing and stays in that status. Then the particular community knows that it's going to take 10 days to receive the paperwork on that report. As a result, they have to stay in contact with the new hire during that time so they do not lose them to another employer. Sometimes they do because they can't wait for this process to occur and they cannot wait on the community and they end up taking another position.
Okay.
Those are my.
Do you have any solutions to this, Dana?
I think some potential solutions are really examining the process to make it more expedient.
Okay. Any questions of Dana?
Chairman.
Yeah, Senator Serval.
Ms. Parsons, thanks for your presentation. I guess my question would be, I mean, are you aware of people not hiring people who have criminal histories because it just poses too much risk, time, and hassle? I mean, you know, as I mentioned, there's some states where a person can go to court and get an order, or they can show an employer and say, "Hey, I got this order," and then you don't have to worry about the employer doesn't have to worry about liability. I mean, are you, you know, aside from the headache of having to do this for every person, are you familiar with people just not hiring people because it's just too much of a pain and there's too much risk and there's too much liability, even if they could?
Well, I know that our communities are always taking the interest of the residents into consideration. And even if a particular crime is not a barrier crime, but they think it poses too much of a risk to the welfare of their residents, they would not extend an offer and enter into the process.
Okay, thank you.
Okay, any other questions? Okay, as we go forward, be thinking of how do you resolve this in a practical way. One thing, for example, an employer to know and say, well, we're not going to take this person because it may be a risk. There's another thing to say, well, we'd like to take this person, but it's too much of a hassle or there's a barrier that we cannot overcome. So these are the issues I'm trying to deal with. Okay, moving on to Marcia Teeterton, is that it? Virginia Association of Home Care and Hospice?
Yes, thank you, Mr. Chairman. I think Senator Edwards, you and I have worked on barrier crimes. This will be our 25th session, if I'm correct. And thank you for your passion on this. We really appreciate all the work you've put into this. And subcommittee members, thank you for the opportunity to talk about barrier crimes. My name is Marcy Tedderton. I'm the Executive Director of the Home Care and Hospice Association, and I'm also a gerontologist. So I have a real passion for older adults and the care for older adults. You've already gotten some pretty good background from the Health Department and the Department of Social Services. Home care, I think you're all familiar with what hospice does. Home care and hospices are predominantly done in a private residence. There are two different types of home care services. There are the skilled home care services, which are often short-term after a hospital stay, and they may be for 30 to 60 days. And they're more recuperative in nature, and they're provided by generally by a licensed healthcare professional. And then the other side of our home care is the long-term care types of services that are provided in the individual's private residence. And that would be assistance with ADL, some light housekeeping, meal preparation, and other chores and errands like that. So, and as you've heard over the years, there's been many changes in the barrier crimes. I think most recently, Sarah, as Senator Edwards says, Sarah Stanton did an excellent job in 2017. Reorganizing the code sections to bring consistency. There were also a number of barrier crimes that were removed from the statute at that time. We see this as an important hiring tool for our agencies. Mr. Servell, I hope you didn't check out on me yet, but I did want to make some comments about the insurance questions you were asking. Yes, you were absolutely spot on, Senator. There are issues with insurances. We have had agencies that have made decisions to hire someone because that 5-year period has passed and it was a misdemeanor. It was a theft issue. And so the person did commit a theft in the home, and the insurance refused to cover it, and there were legal fees and so forth. So yes, there is an insurance component to this for home care and hospice. So perhaps if there were some sort of way to provide some type of immunity to organizations in those particular narrow instances, that may be a good approach to look at. I will say that some of the other issues, and I really jotted down some of the questions and issues as we've been going through this. Dana brought some of them up. We do have issues with providers that are particularly close to state lines. They want to do the multi-checks. We're somewhat limited right now. I will say that state police regulations for the criminal background checks are different than Virginia Department of Health. For example, state police will allow a third-party vendor that uses the state criminal background check exchange to do a background check and pick up multi-states at the same time, but it does require a signed affidavit. So that's a bit cumbersome. That is very inconsistent with what you heard earlier from the health department regarding their requirements. The state police, they go in and do inspection of providers, and they say, you're not supposed to have the original criminal background check in this personnel file, but yet our state licensure statutes require us to have that in our files. So we have some inconsistencies. I think Dana pointed out some lag time issues. So I think those are all issues that we could look at. The state police also have a very unusual process for invoicing providers. My understanding is they don't accept credit cards, that you actually have to cut a check and it has to be in a special colored envelope. And if it's not in that envelope, when it's submitted to the state police, it doesn't get processed, and they will cut a provider completely off and not allow them to do any more electronic background checks. So, and we've talked to the state police about this a number of times, and we really don't seem to get any real resolution to that. So I think those are sort of my flying high issues that we have really with the regulatory inconsistency.
Okay, any questions for Marcia? Well, you brought out some very interesting questions. I didn't know a lot about what you just said, but I think it's very important that we get this on the table. The differences between, say, some healthcare providers and other providers. Now moving on to behavioral health and private providers. Jennifer Fedura, Virginia Network of Private Providers, and she also, Jennifer is Virginia Network of Private Providers. Jennifer Fedura.
Thank you, Mr. Chairman. Jennifer Faison with the Virginia Association of Community Services Board and I are actually doing a joint presentation.
Okay.
I'm going to share the slides on her screen. We'll hope we can make this all work smoothly. Thank you for the opportunity. We appreciate it. I'm going to cover a few of what we see as being the challenges, and Jennifer then is going to pick up on what we think may be possible solutions. So we hope that it flows smoothly. I want to start briefly by saying that as a caveat, since the invitation to present, we've not had the opportunity to vet these ideas with our memberships or with our consumers. We know from our long experience in dealing with barrier crimes, and Marcy said she had been working with you for 25 years. I've been at the General Assembly for 30, and I'm sure that we've been working on this for 30 years. So with our long experience, we're pretty comfortable with what we're presenting to you today. And one of the challenges that we are looking at, and Jennifer, if you can go to the next slide, and I think many of these have already been mentioned. There will always be examples of individuals who committed a barrier crime and who would never do it again. But our system is currently built on a list of crimes, with some exceptions, and we'll talk about those in a minute. But because it's built on a list of crimes, as opposed to on an individual's behavior or predicted behavior, if you change the statute so that one person's crime is no longer a barrier, you end up changing it for everyone. And that has been the bugaboo from the beginning. No exception or relief processes or procedures, and this is directly to Senator Sturvill's points that he's been making, has made several times this morning. If there are no employers willing to hire or able to hire a person, even if they've gone through an exceptions process or they've been granted relief from the court, if there are no willing providers because of liability issues or because of insurance issues, then the exception or relief processes that we have are not very helpful. So to Senator Sturvill's points that he was making with his questions, that is certainly something that I think we want to look closely at. Another challenge is that over the years, crimes have been added, as I said earlier, as barrier crimes are removed, and they've been added or taken off the exceptions list, largely based on the kind of examples that we've had. And we've seen this morning examples of individuals that we would all probably agree should be hired and can't be. So the issues that we see are again adding crimes to or taking from a list. The other thing that I really heard this morning, and I heard it clearly when social services spoke and when the health department spoke, the inconsistency in the exceptions. And we know from the history of the of how this has all evolved over the years that each time there's an attempt to change something, it is focused on a particular set of code sections, such as the mental health code sections or social services code sections. And because of that, exceptions get built in that are not then consistent across. And if the Commonwealth has some sense of the protection of vulnerable populations balanced with the need for recovery for individuals, if they have some overall sense of that, then there should be some consistency. We're not going to engage this morning in any discussion of what crime should or should not be on the list. I think that's not the solution that we're looking for. So I'm going to stop here with the challenges, and Jennifer Faison will pick up with how we propose to attack this.
Good morning, Mr. Chairman and members of the committee. Jennifer Faison, the Executive Director of the Virginia Association of Community Services Boards. And so I think we've had a little bit of conversation this morning about some possible solutions and how we might organize our thoughts around some changes that would be helpful. Again, you know, we're kind of putting ourselves out there, recognizing that there's a group of stakeholders here that is not present here, which is the individuals that are subjected to these barriers as a result of their criminal histories. And so, you know, I'm sure that they would have some opinions as well. And these are just kind of our impressions about what has, you know, based on what's occurred over the years. And so if we were going to look at this comprehensively, I would say that there is an opportunity to look at the barrier crimes at present that already kind of expire naturally. And if you could consider either saying, you know, we agree that this entire class or classes of crimes could potentially, you know, they're okay to expire after a period of time, identify those, and then remove them from all of their individual sections of the code and notate in 19.2, 392.02 that there are no longer barriers to employment after a certain number of years. And it would be great if they could all be the same number of years. And then the other thing is to keep in mind that you want to be clear about whether it's from the date of, is it 5 years from the date of conviction? Is it 5 years from the end of parole? Is it 5 years from the time you paid your fine or probation rather? Is it 5 years from the day you paid your fine? And so I think that, again, to Jennifer Fedura's point about consistency, that's really something that should be considered if we're going to look at, you know, can we all agree that there are these kinds of crimes that, well, we have already agreed there are certain kinds of crimes that can naturally expire as a barrier. So let's be diligent about that, get them consistent. And then if they're in 19.2, 392.02, then they're not kind of individually in all of the other HHR kind of related sections of the code. And we believe that that would address one of the issues that has been discussed this morning of you know, consistency across the organizations. And Senator Somerville, you had a bill in 2016 that we think was a promising concept for relief. Now, we did not go through it with a fine-tooth comb, nor did we invite our legal counsel to review it prior to this call, but it's something that we could keep looking at. And I am assuming that that bill is built upon the foundation of the North Carolina model, Senator Somerville, that you were discussing earlier. And so, we do see some advantage to an individual relief process because essentially, as Jennifer Federa said, the relief process right now is for that individual to take their case to the General Assembly and to have their one specific incident removed from the list of barrier crimes or have an exception created for it, except for you're not really creating relief for that individual. You're creating relief for any individual under any circumstance with that particular barrier crime in their history. So the concept of relief as tied to an individual situation and their behavior over a period of time makes more sense to me than a concept of individual relief that requires the full General Assembly to change the statutes in the Code of Virginia. The other advantage to something like a relief process, if you were to tie that to the courts, the prospective employer might have some comfort, some additional comfort in that hiring process. Again, depending on how that played itself out and what it looked like when it popped out of the end of the process, do you have a piece of paper? What does that piece of paper say? And we think that, if you go this route, really you should be able to seek relief for any crime on the barrier crimes list, because again, what we're saying is it's not necessarily the crime, it's the individual situation and behavior that we're looking at to determine whether they're suitable for employment in that setting. And so what we would recognize, though, Senator Somerville, is that if we did, and other members of the committee, if we did have a process that involved the courts, there's a potential for that to become arduous and it may be a situation of time and resources for the individual who would like to be employed, and it might be difficult for them to go all the way through a courts process. And so either as an adjunct to, a complement to, or keep maintaining it in place. You heard Stacy Pendleton with DBHDS talk about the current screening process that is available to some individuals in some circumstances when they are applying to specific programs. And so if we looked at that screening process and modified and strengthened that, that could offer an avenue for those specific individuals, and that's specific to individuals who are applying to work in programs related to mental health or substance use disorder and adult serving only, that there could be this kind of screening process for relief that would not necessarily have to involve the courts. And so if we were to think about this comprehensively and think about what we would like the intended outcomes to be of any kind of process for making the barrier crimes, striking that appropriate balance between wanting to protect the individuals that we serve and at the same time really put our money where our mouths are in terms of recognizing that recovery is important and that meaningful employment is a component of recovery. When we think about that together, in some way, shape, or form, taking the steps that we outline would obviate the need for an exceptions list, right? Because what you're saying is the list of crimes is a list of crimes, and you can make your case about why you, individual X, should be considered for employment Y. We believe that we would be able to increase consistency and decrease confusion, not only for the employers, but also for the individuals who are subject to barrier crimes restrictions. We see often cases where individuals aren't aware, they may have gone all the way through a licensing process or, become a certified peer recovery specialist and then realize that their intended employment option is not open to them because they were confused about the statute. And then also, the objective would be to reduce confusion for the employer as well. And again, a cornerstone of recovery is meaningful employment, and we would support any moves that would create that pathway and make it easier at the same time that we're protecting our most vulnerable individuals. And we will, I'm going to turn it back over to Jennifer Fedora just briefly before we take questions, in the event that there's anything that occurred to her as I was speaking, since we're doing a tag team this morning.
Okay, Jennifer Fedora.
Yes, thank you, Jennifer, and thank you, Mr. Chairman. I want just to kind of building on the experience that we've all had at the General Assembly. If you are someone who focuses on the protection of the most vulnerable, the developmentally disabled, the frail nursing home population, young children, if that is your focus and you're focusing on their protection, it seems like the list of barriers can never be long enough. There's always one more to add. And if you are focused yet on recovery and the options for individuals who have lived experience to be able to have a path to employment, then the list is just an overwhelming barrier, and you can't get by it. So I think what we're proposing, and I hope we were able to articulate this, is utilizing a couple of methods that might be out there, plus adding some consistency across nursing homes and childcare facilities and DD facilities. Let's be consistent if we nothing else. But to look at this as a way that we can pick whatever list you want to pick, crimes, and figure out a way to provide some relief on an individual basis for that, as being that with enough teeth in it that you will have a willing provider to hire that person. So that combination of things is what I think we're going for. So we're happy to take any questions. I hope we've been clear with what we're hoping for.
Any questions?
Mr. Chairman.
Yeah, Senator Searle.
Thanks. So first of all, I appreciate you all noticing my bill from 2016. I think I presented it. Nobody testified in favor or against it, and it was swiftly killed in committee, and I didn't think anybody was paying attention. So thanks for noticing. Here's my question. You mentioned childcare there at the end. And for example, we have a childcare chain up here in Northern Virginia. It's now been sued, I don't know, 3 or 4 times by one of my colleagues because they have problems with children getting sexually assaulted because of by different people who are hired. And I have no idea what the individual circumstances have been, whether the people who were hired had criminal histories or not. But in those cases, but it would strike me that those types of claims are putting a lot of pressure on insurance premiums for childcare facilities up here, and that no matter what we do, we can pass anything we want. The insurance carriers still might be placing requirements on these people they hire and say, we don't want you hiring anybody with a criminal history. There's, we have this whole history, and it's going to increase your claims, your likelihood of getting a claim. And so Mr. Chairman, I think at some point we probably need to take some testimony from somebody in the insurance industry, because it's hard for me to see. We can do all we want on the regulatory side, but if insurance carriers say, hey, you can hire all the redeemed, vetted, validated people you want, but as long as you can get sued for it, we're still going to jack your premiums up, and that still might dissuade people from hiring anybody anyway. And so are you all familiar with insurance being a problem or third-party certification being a problem? I mean, I'm wondering whether there's any other sort of structures out there that play into this besides just whether the person can get a license or not, or whether they're going to get audited and get violated by the regulator or not.
Senator, I I would have to do a great deal of research to find out about all of the individual requirements of our accreditation bodies and that kind of thing. But you and I don't think we're going to solve all the problems of the world here, though maybe we could try. It seems to me that some kind of a court-supported relief that was, and I think you mentioned before that it granted immunity to the provider.
North Carolina does. Yeah.
Yes. And so, I mean, if we could get to that, and I'm no expert in insurance, except that, you know, I've spent my life trying to have lower premiums. I think if we could get to that, we're well on our way. Because if you're looking at cost from the perspective of a provider, we are all in human services across the board, and I don't think anyone on this call would dispute this. We are all so desperately strapped for workforce that the cost of workforce issues of recruitment, retention, overtime, inability to take on new clients because you cannot find staff to provide for them, all of those things. You know, if my insurance premiums went up, 5%, and I could hire 4 more people, that might offset it. And I'm not advocating that, but I mean it's all about the cost of doing business, and the workforce issues are killing us, honestly, across the system.
Let me comment. I'm not so sure we can do much about insurance underwriting. I mean, that's a separate issue. I don't think we can control that one way or the other. And people's insurance is their insurance, and they have to comply with whatever the insurance underwriting calls for. But I don't know that we legislators can deal with that issue.
Mr. Chairman.
Yeah, Senator Sturgill.
Thank you. I would just note that if an employer had immunity from liability, then the insurance provider therefore shouldn't increase their premiums because there would be no liability. And so that's why I think if insurance companies are placing requirements on the people they're insuring about not hiring people with criminal histories, or if that's playing into the underwriting process by providing immunity for hiring people that have been blessed by someone, that might alleviate that problem. And I'm just concerned that no matter what we do, we could still have other third parties blocking the hiring of these people. If we don't have a solution that's comprehensive enough, we could spend a lot of time doing something that actually, as a practical matter, doesn't end up solving the problem. So I think that's part of it.
Well, my concern is you raise the issue of immunity. You've raised a whole series of issues between trial lawyers and defense attorneys and insurance companies, and that's another ball game entirely. I just seem to try to avoid that issue. Any other questions? All right, let's move on then to child care. Grace Reef, Child Care Aware of Virginia. Grace?
Hi, I'm gonna bring up some slides, hopefully. Okay, can you all see my screen?
Yes.
Okay, good, because I know someone earlier, we couldn't see her slides. Good morning. My name is Grace Reef, and I'm here talking on behalf of Child Care Aware of Virginia. Just briefly, Child Care Aware of Virginia, if you're not familiar with them, a nonprofit, operates statewide, nonpartisan. We work with families to find childcare. We work with childcare providers to help them become licensed or registered, help to strengthen the quality, training of providers. We've actually done a lot of work with background checks. We've been working for the past 5 years with the General Assembly and VDSS to comply with the federal child care law. It used to be that there was a name-based system in Virginia if you wanted to work in childcare, and it's kind of garbage in, garbage out. If you put in an alias, it might not catch you. And we did work with a family whose baby died in childcare, and when the police investigated and took fingerprints, they found she had 5 alias names and was on felony probation for a drug charge at the time. That should no longer happen since the federal law changed, requiring states to have a very comprehensive background check system for anyone who wants to work or volunteer in childcare. But I just wanted to give some perspective. I think the benefit of going last is I've heard everything else everybody already said, so I will really try hard not to repeat anything. But there is a point that I think needs to be made that hasn't yet been made, which is, well, it's kind of a tricky, complicated, cumbersome background check, barrier crimes process for all involved. Some of these stem from federal law. So, for example, with regard to childcare, there are very specific things in federal law which frankly were passed in childcare reauthorization bill in 2014 based on problems going on throughout the country, including Virginia, with the way in which background checks were conducted and some things that were happening in programs to children and families. And so federal government passed some changes, required states to comply. And if they don't comply with the background check provisions, they lose 5% of their federal child care money. So it's maybe $100 million or something. It's a lot of money. It is complicated. There are lots of different checks. I heard previous people talking and questions about, can you use a third-party vendor? How does it work? These checks are very specific. They do go through the state police. There is Field Print who takes live scan, prints. There is a state criminal history check. It is also forwarded to the FBI for an NCIC check. It also involves checking the state and federal, state and national sex offender registry, state child abuse registry. And this is a little complicated. And, I think in a very small percentage of cases probably slows the process down. If you have lived outside of the state in which you want to work in childcare, over the past 5 years, you have to go back and check those other states and see if there's a record. There are a couple different agencies involved, which also makes it complicated because the criminal records are, really with the state police, but child abuse is not a state police issue. Child abuse registry is something held by the VDSS. So even when child care and licensing transition over to the Department of Ed, which they will later this year, still it will be a cross-agency journey to get a background check done because one piece it involves criminal records in the state and then at the federal level, FBI. And then the other is the other agency who hosts the child abuse registry. The reason, as I mentioned, is there were things going on throughout the country, including Virginia, that would just not give for kids. And I heard one of the Jennifers say, if you're working with a vulnerable population, there probably aren't enough barrier crimes. And if you're working to rehabilitate people, give them a second chance, you're looking for fewer. I feel like where childcare, where Virginia is we just want the process to be consistent. We just want the process to be fair. We just want children to be safe in childcare. I actually clicked on all of the barrier crimes before today just to make sure I remembered them all. And you can see a picture. I put them all out on my kitchen table, took a picture, and the code. I mean, I counted over 160. Somebody testifying said today there were 175, whatever that number is. The federal law with regard to childcare is kind of broad buckets, murder, child abuse, a crime against kids, spousal abuse. Each of these things across the United States within each state may be defined differently. And maybe that's how, there were 160 plus barrier crimes in Virginia that popped up. I'm not really sure. I feel like we just want the process to be fair, and we just want want children to be safe. What I do want to flag, because I think this is a barrier crime issue that needs more attention. And, some of these crimes, I heard, some of the anecdotes that were mentioned, oh, this happened 20 or 30 years ago, it's still on somebody's record. With the drug possession issue with marijuana, for example, I'm not really sure if it's the waiver process is not being applied consistently, if it's that the waiver process is not working as intended, if it's that some communities are disproportionately impacted by systemic issues of who's stopped for offenses, who's charged with offenses, who's convicted of offenses. And so I did put a screenshot because I think particularly with home-based care, and we in Virginia have, many home-based childcare providers, and often they might be families of color. And so if, for example, the husband or partner or another body that's living in the home happens to have, a possession charge, and that prohibits the mom, usually it's a mom, who wants to be, or the female in the home, usually who wants to be a child care provider, prohibits her from getting a license or being registered. I think it's something to review. It's something we'd like to see the data on. We haven't. What I did, because anecdotally I had heard this happening, it may be the law's not being applied consistently, or it may be in some areas in the state more than others. I'm not really sure. I was anecdotally told of how this is happening and impacts families of color looking to register or be licensed as a family child care home. We'd like to see data on it. I also don't know. I know last year or earlier this year, the General Assembly took action to decriminalize marijuana. And then yesterday, there was some kind of announcement from the governor saying he was going to legalize it. I'm not real sure where that all is. But if somebody was convicted in the past of, a possession charge, how that's impacted in the look back in employment, or if you're a home-based provider and you want to get a license, how that plays out. So I just flag it for an area of review. It would be good to see some data. It would be good to make sure that the appeals process is done in a, consistent and fair manner. One problem we see, so I heard, I think it was Senator Edwards say, what recommendations do you have? So broadly, this is a problem. If you're a teacher and you work in the public school system, and you go to a training, or you're sick and you can't come into work, or there's a family emergency, there's a pool of subs, and those subs can come in and take your place so that the children still learn, the school still stands up. With childcare, we want to work with communities too, to have a similar system of subs who can go into a childcare program and stand in for the day, in cases where, a lead or assistant teacher can't make it. But there's a problem with the background check statute. So we have been working on this, bill keeps dying, but maybe this is the forum to have that discussion to better understand what's going on and how can we better construct this statute. So the way the child care background check statute works, the code sections which I've listed, is that when you get a background check, do your live scan print, that's tied to an individual provider. So if a community wants to have a sub pool, and let's say there are 10 childcare centers who want to work in an alliance and share subs, because that's cost effective and they can go to a trusted bank of people who've already been background checked. They can't do it unless somebody goes to that live scan machine, puts their hand on the machine, has their prints taken, and they stand there for 20 minutes getting 10 separate checks so that each childcare center can physically hold their own clearance paper that this person can work in this childcare center. And, it's $50 a pop for, or a little more for a background check. So that's $500. Now, right now, the state is picking up the tab for that, but someday that, won't be the case, and individual people seeking to work in childcare will need to pay. But whether it's federal funds you're wasting at $500 to get 10 prints so that a sub could work in 10 places, or whether, it's an individual's money. I think there's a public responsibility to have some common sense to this process. The school systems, there's a state law that allows portability of background checks for schools. It's reciprocity between, school districts. The concept is similar for what we'd like to see in childcare. The details differ because, really the Department of Ed or Department of Social Services would have to be the holder because there's no school board. But basically, portability is a concept. It makes sense. Other states are doing it. I listed several. To give you an example, I didn't quite realize that Senator Surville was going to keep mentioning North Carolina, but I do work across 10 or 12 different states. North Carolina is one. And I have heard North Carolina, I have spoken to people in the childcare background check office in North Carolina and asked them about problems they have with interstate checks. Somebody wants to work in childcare in North Carolina, but they used to live over the border in, let's say, Virginia. And when they go to clear that person to work in North Carolina, because the person previously worked in Virginia, they actually have to go to the provider because the childcare provider, the childcare center is the one that holds the background check record. And so that's something that we can fix. It's a frustration to other states who try and get background checks out of Virginia because it's not through DSS. They might pass through it, but they actually have to ultimately connect with the individual provider who holds the record. So it's fixable. I'm just flagging it. Last, the barrier crime issue is a piece, but really it's the process. The process is, I heard somebody else say, takes several weeks to get a background check. It does, and it doesn't have to. And so in 2018, in response to state legislation, there was a review by the state police. They issued a report. There were recommendations. I think the recommendations have just been sitting on a shelf. You may want to just, take that report back out, look at the recommendations. The state police have said they're using an antiquated system. It takes a long time. It often has errors. It needs IT fixes, but it is way more cost effective just to get a new updated system than it would be to patch the old system with a large number of fixes that would be needed. It's documented in this report. So I'll leave you with that. And I'm glad to answer any questions. Childcare Aware Virginia wants kids to be safe in childcare. We want portability, so there could be subs that work in childcare centers, just like in the school system. And to the extent possible, if the antiquated software system used for the background checks were replaced, the state could get wrapped back, which is probably the safest way to ensure that that background check that occurs is not just a snapshot in time, but it's real time. If somebody were to be convicted of other offenses, the information comes back and you make sure that the people working in childcare won't be at risk to kids. So I'm glad to answer any questions. And I will.
Any questions?
My screen back.
Any questions? It's been very helpful. What's the state police doing so far since 2018? I guess they need a lot more money, I'm guessing.
Well, they do, but here's the issue. I think that's a false issue. I think part of the problem is nobody owns this. So we've been working hard to get DSS, DOE, maybe the behavioral agency, maybe the agency that's involved with nursing homes. I mean, I work with kids, so I'm not really familiar with that. But it's like nobody owns this issue. If we could get them all around the same table, including the state police, we could have a cross-agency discussion and everybody could contribute. The state police report says this would cost about maybe $3.5 million to fix, but there's a charge on background checks. And so they actually can pay for themselves. And so if we could get the right people around the table, even through Zoom, to have the discussion, first, it can be self-financed because there's a fee for background checks. Second, there are sources of funding, like, and some of it's federal, that could be used for this, where it may not cost the state at all, but it's, I think, difficult to address because people know their own narrow silo, but they don't know across areas of potential funding, what could be used. For example, child care and development block grant money could be used. The preschool, it's called PDG Birth to 5, preschool development grant birth to 5 money could be used. The coronavirus relief funds, which are federal, which have to be spent by December 30th. I mean, maybe they'll be extended by Congress, maybe not, but to have a group in a cross-cutting way, sit around a table or join a virtual Zoom and talk about potential sources of funding where people would think in a cross-cutting way, I think these are problems with solutions. And I think on the portability front, that could be a low-hanging fruit. We can do this. It has to be done through the statute because it's a statutorily created problem that the providers have to hold the prints. And so that could be fixed. But I think the discussion is worth having and stop narrowly looking at these issues in a silo and start cross-cutting discussions.
Okay, any further questions? Well, thank you very much, Grace. You've been very helpful.
Thanks.
Now we move on to presentation work plan by the DLS staff and discussion between members regarding directions to the agencies. So Anna?
Sure, thank you, Mr. Chair. So in the work plan that we sent along with the other materials, you will see in the first part that we set out what we accomplished in our last meeting and today in this meeting, which is our final meeting in 2020. In the second part, we set out a rough plan of what the joint subcommittee will do beginning next spring and throughout 2021. Actual meeting dates will be determined at a later date. This is just a draft and is subject to change when we come back in the spring after the General Assembly session. The work plan is designed to address each of the issues posed in the joint resolution. So in order to hit the ground running when we return in the spring, the joint subcommittee is going to direct questions to address over the winter to the Department of Social Services, the Department of Health, and the Department of Behavioral Health and Developmental Services. Those agencies will be directed to report back by April 1, 2021 on the questions posed by the joint subcommittee. So hearing from those agencies and hearing the stakeholder responses to the agency information will be the first things that the joint subcommittee will do when we come back. And then we will continue building from there and move toward creating a comprehensive draft. We generated a list of questions and data requests to look into over the winter for the agencies in consultation with the chair and the vice chair. The current list of questions are for the agencies are 1, what should and should not be a barrier crime? 2, whether there should be a time limit following conviction when a crime is no longer a barrier crime and what such time limit would be. 3, whether there should be an exceptions, waiver, or appeals process and what that might look like. And 4, demographic data on individuals for whom a background check is completed and for whom a criminal conviction is a barrier to employment, licensure, etc. Mr. Chair, I know that we set aside time, or we wanted to do a discussion among the members, but I just wanted to offer the option that in the interest of time, you guys can also email your questions that you want to go to the agencies to me, and we can do it that way, or you can have a discussion now. It's at your discretion, Mr. Chair.
Okay, any questions about the proposed list of the work plan?
Mr. Chair?
Yeah, Mike?
I apologize. I was in court all morning handling
Did you win?
9 prelims. So,
Did you win?
No, not all of them, but I hope justice was served.
Good.
Has there been a discussion about creating tiers of barrier crimes as well? I know that we sort of have blanket barriers as we speak, but for example, one of the things that greatly concerned me, and I mentioned at the last meeting, was barriers to adoption. And I wasn't sure whether or not other states have operated with a tiered system or if they have sort of a blanket system similar to what we have.
Any questions about that? One of the Jennifers?
I think I could probably take that, Mr. Chairman. Gina Berger, DSS. I think Delegate Mullen's question was about adoption.
Yeah.
So we can provide for you. We've been looking into the possibility of trying to put together some legislation this year to remove some of the barrier crimes for kinship foster parents and others. And so we have taken a look at other states. And my understanding is we are one of the strictest states in the country in terms of barrier crimes. So we go well beyond what the federal government requires in terms of prohibiting. So I can get you that information. That can be something, Anna, that we bring back as DSS.
Okay, good. Thank you.
Thank
Any
you.
other questions? Yeah.
Mr. Chairman.
Delegate Price?
Yes, thank you. I just wanted to, I'm trying to keep all of the screens up, but just wanted to reiterate information on recidivism and just, I guess, some of the pushback that we've received is, but they're going to do it again. And I have not thus far seen or been able to find comprehensive data that says, the success rates or recidivism rates for certain crimes. So when we're talking about what should be a barrier, what shouldn't be a barrier, I think that would be helpful in painting an accurate picture as opposed to anecdotally or operating off fear mongering. So I just wanted to reiterate wanting to have some recidivism rates and data as we move forward if possible.
Okay. All right. Any other comments or questions?
Mr. Chairman.
Senator Sherville?
Thank you. First of all, I guess one of my, it's a question, but I'm curious as to, it seems to me we're limiting the inquiry here about barrier crimes with regard to these sort of DSS kind of healthcare related professions. I was just poking around some, but I mean, virtually every single profession that's regulated by DPOR has a prohibition on hiring felons. And I mean, you can't even be like a plumber or something, I think, if you get a felony conviction. I'm not sure, but like there's a whole category of offenses that we're not picking up here. There's also, I believe, other types of barriers in the code. I'm not sure whether because they're not called barrier crimes in 19.2 but they still create barriers for people. For example, I think you can't be an ABC manager or something if you have certain convictions. There's a whole series of other legal restrictions in the code for which people, I think, that are employment related, that people might want to seek some sort of relief, which is what I think our inquiry here seems very narrowly focused on the DSS process. But this problem is bigger than that when it comes to employment, which is why I think examination of a court process is important here, that we can't just focus on the health related professions only, number one. Number two, I would like to see a survey of what has been done in other states and sort of where we stand in other states on all these issues. Just, I have the impression that we're behind everybody else, or not as permissive, but I'm most concerned about the states right around us, but because that's who we compete with. But broader than that, I don't know if there's any resources out there that provide information about that. And again, I remain very concerned that no matter what we do here, the private sector behavior might not change unless we provide the private sector more assurance that it's not going to cause them a problem either with their insurance company or with a trial lawyer if they take the chance on hiring somebody who has been cleared. Because even if they do get cleared with this conviction, the employer is still going to see it on their background check and can still decide, I don't want to hire the person even if they have been cleared. And I think that at the end of the day might be a problem. If you're in a robust job market where you have 5 applicants and one of them has a felony and the other 4 and has been cleared, but the other 4 doesn't, my guess is the employer just looks at the other 4 and skips the person with the felony, because that's just the easier thing to do. Because you start making speculation and assumption about it. But if that person says, I have this thing from a judge, you can never be sued over this, that's a whole different thing. And I would think an insurance carrier would also treat that differently in terms of adjusting risk. And so, I know you're not, and Mr. Chairman, you don't seem to think insurance is part of this. I think it's a big part of it. And I also think sort of stakeholder how their hiring processes work play into this a lot, because we can, again, just give people all the green lights we want through the regulatory process. That doesn't mean they're still going to get hired unless they're in a really tight job market and they're like only one or two people applied and they both have criminal histories, and that's who you're hearing about in Southwest Virginia. That's who you have to pick from. And so I think we maybe need to look a little more broadly.
Well, let me say, we probably disagree on this. I've actually tried negligent hiring cases very successfully, and it's a loose issue. I mean, there's defenses, and they're not defenses, and I don't want to get into this immunity issue. I think it's going to stifle what we're trying to do here, because you're adding up a whole nother area of dispute that I don't know how we're going to resolve with this barrier crime. So I don't really want to get into the immunity question. I understand where you're coming from, but it's not black and white either. The whole question of immunity with negligent hiring in particular. And like I say, I've had experience in doing those kinds of cases. But anyway, do we have a work plan here? I think all these comments are really good at doing national studies. What are other states doing? And all these comments I think are very helpful. So maybe, Anna, you can make a list of all the different comments that have come about. And are you prepared to go ahead at least for the time being, approve a work plan for 2020, 2021 that's set forth in the paperwork I think you were given? I think one of the questions that's been raised by one of the Jennifer Fedora, I guess, about they don't want to go through each of the various barrier crimes. They do categories. That's one way to look at it too. But we certainly need some kind of relief valve in certain situations. Yeah, Mike Mullins?
Mr. Chair, I think actually Delegate Price had her hand up first, and then I also had a question. Okay. I just had a quick question because building off what Senator Searle said, I wonder, there's a fine line between what constitutes a barrier versus what constitutes a collateral consequence. And so, it is obviously the prerogative of the chair as to what we should be handling here. I know that prior to you, Senator, being here when in the last meeting, I had mentioned the most significant collateral consequence that I see on the day-to-day in general district or circuit court is immigration, particularly in misdemeanors. I know about 7 or 8 other states, including some in the South as well as in the North, have amended their misdemeanor statutes to bring about 364 days instead of 365, so as not to trigger possibilities of immigration consequences like deportation on misdemeanors. I'm not sure whether or not this would be the forum in which to discuss that, but I think that that's something that we really need to address at some point, because that is, for what my observation is, probably the biggest collateral consequence of a misdemeanor conviction.
Delegate Price?
Yes, I just, I think what, I'm trying to word this correctly. So I think that what I'm seeing is really good for an immediate, and I think one of our first meetings, I was asking if we could do kind of like a tiered work plan. I think what's important about that, even if it's just saying we look to do this later in 2021 or 2022 even, is that it states our priorities. And I think incentivizing or getting rid of the obstacles for people to eventually get hired is a goal, then I think a little bit more needs to be in the work plan, at least stating that we're going to get to the insurance, or that we're going to get to how to incentivize folks to be hired. Like, for instance, if you have to pay your fees and fines, but you can't get the job to pay those fees and fines, like some of the real life consequences that these policies are having on folks that are trying to enter into the workforce. I just wonder if there isn't a way that we can list some of our other priorities at the bottom, even if we don't have a necessary target date for them, so that the public document can reflect the conversations that we've had.
Okay. Well, we have in front of you a proposed draft work plan. You want to make any changes to it? And we're going to go meeting next year at some point. Is there a motion to make any changes, or would you like to move forward at least to get started with the current draft work plan that staff provided? There's a motion. Not to hold back any of the other suggestions, but at least to get started on a draft work plan that you have in front of you.
Mr. Chair, then based upon Delegate Price's request, I would make a motion consistent with her request that we include some of the lesser priorities, certainly at the bottom, so that we can at least include those for some potential further date, even if they're not to be addressed in the first year.
Right. Okay.
Second.
Okay. Second. Any
I think,
discussion?
Mr. Chairman, I think staff, Anna had something she wanted to say.
Who? I'm sorry.
Oh, no worries. Thank you, Mr. Chair. Yes, and I just want to reiterate, this is still just like a draft of a plan. There's flexibility in this plan for us to do that. And I actually kind of tried to start doing that under meeting 4, you'll see, to try to pull some of those things at the end, like private background check companies and collateral consequences and all that. And I'll continue to add to my list some of the stuff that we talked about today to make sure that that's in the work plan. But I don't think we need to vote on this work plan. I think it's more just, it can be a working document for us.
Then, Mr. Chair, I'd withdraw my motion.
Okay. All right. Well, then with that, let's do it this way. Without objection, the draft work plan plus the additions that have been raised, we'll go forward with it. Is that okay? Without objection. All right. I have down here a vote on a continuing resolution. What is that, Anna?
Mr. Chair, that was sit in the documents with everything else. It's to continue the study for another year, like we discussed in the last meeting, and I believe that the clerk will help you all initiate that vote.
Yeah, I think the joint subcommittee study works for 2 years, 2020 through 2021, right? Automatically. That's my understanding. Okay. All right. Is anything else to come before the joint subcommittee to study barrier crimes? Anybody else have any comments? Thank you all very much, especially the agencies and the stakeholders. Yes.
Anna?
We do need to vote on the continuing resolution to make it official to be able to continue for another year.
Okay. All right. I thought is a 2-year anyway. Okay. Is there a motion that we adopt the continuing resolution to continue through 2021?
Yes, so moved, Mr. Chairman.
Second.
Okay.
All right.
Moved and seconded that we adopt the continuing resolution to continue through 2021. Would the clerk call the roll?
I believe
vote virtually with the thumbs up or down, as the case may be, and then also vote yes or no. Call the roll.
Yes, Chair. Senator Serval.
Aye.
Delegate Bagby, I believe, is on. All right. Delegate Mullen.
Aye.
Delegate Samira. Christy Kelly. James Abrenio,
Aye.
Delegate Price,
Aye.
and Chairman Edwards.
Aye.
The vote is unanimous.
Delegate
pardon me?
Bagby votes aye.
Thank you. Delegate Bagby votes aye. Vote is unanimous.
Okay. Well, if there's nothing further, we'll say the meeting's adjourned. Thank you all for coming. I think